Prosecutors are allowed to introduce evidence of a defendant's consciousness of guilt at trial. So essentially, if the defendant does anything to evade police or to thwart their investigation, this could be considered as his consciousness of guilt, that he's aware that he did something wrong. So things such as running from the police, lying to police, giving a false ID or a false name to police, bribing witnesses, threatening witnesses, any of this could be used to help bolster the prosecution's case that the defendant is guilty. So the prosecutor will ask the judge to give the jury an instruction on consciousness of guilt. The judge will tell the jury that they can consider it as part of the evidence against the defendant. However, things such as running from the police and lying to the police, bribing witnesses and such, cannot on its own be sufficient for the overall conviction. There has to be additional evidence. It should also be noted that refusing to speak to the police is a constitutional right, so that cannot be used as evidence of a guilty conscience. And the defendant is not required to voluntarily hand over evidence to the prosecutor. Okay, if he fails to aid in the prosecution's investigation or in law enforcement's investigation, that in and of itself is not consciousness of guilt. So I've written a blog post about this, and I'll put it in the description below.